Hello everyone and welcome at this mini lecture in which I will explain the 6 distinct sources of law. The first source of law we can distinguish are codified standards. Codified standards are basically written rules, codified rules if you like, that helps us understand how we organize just behavior. We can make a distinction between international codified standards, we call these treaties. They are between countries or a group of countries, and national domestic legislation, mostly adopted by a parliament or another ruler, and that enables us to predict beforehand what the consequences of our legal actions will be, because it's written down in textbooks, in law books. A second source of law would be the application of law. Sometimes we need to apply legislation in a particular given case to make it more specific. In most countries this is done by the courts and tribunals who produce case law. This case law is basically an application of law. And it could be, for instance, an interpretation of codified standards, to make it more colorful, to make it more specific, to apply these codified standards on a particular given case, and in doing so give a particular meaning, a more detailed meaning to the wider codified standards. But sometimes also in certain societies, especially in the common law traditions, we see that the courts in itself have their authoritative chain of case law that becomes a rule in itself. So the courts do not necessarily look at codified standards, but they look behind, they look at what their colleagues or what they did themselves in the past in similar cases, and they produce case law that is according this authoritative line of case law in itself. We also label this as stare decisis in Latin. Sometimes we see that the administration is responsible for applying the law, for the application of law. And this is mostly done in the case of administrative procedures, naturally. And this has to do with permits or the understanding of particular community regulations in which the administrative authorities in a country administer the law in itself. Sometimes it's a bit less popular to say these things, but sometimes we have a military rule, and then the military, the army, is responsible for applying legislation. Mostly this is a temporary situation in which the military, for instance, commits a coup d'etat, but sometimes we have a long-lasting military regime in which the military is primarily responsible for applying the law. A third source of law would be legal writings and teachings. At some point, judges, courts might refer to the works of academia, who did research in a particular field of law, who have an opinion about how to use the law in a particular way. So the courts literally refer back to publications of academia. Therefore, we consider legal writings and teachings also a separate source of law. A fourth source of law would be religious writings and teachings. We have two kinds of states, basically. We have secular states and non-secular states. In a secular state, there is a clear distinction between religion on the one hand and governance on the other hand. They are separate from each other. However, in a non-secular state, there is no such thing as a separation between religion and state affairs. It's merged. And therefore, in such states, we see that religious writings and teachings are, or could be, a fundamental source of law. For instance, when we take Article 1 of the Constitution of Saudi Arabia, quote, it says, "The Kingdom of Saudi Arabia is a sovereign Arab Islamic state with Islam as its religion. God's book and the Sunnah of his prophets, God's prayers and peace be upon him, are its constitution. Arabic is its language and Riyadh is its capital." So it's quite important in this country to understand the holy writings and to be able to use this as a source of law. A fifth source of law is customary law. Law is not always written down. It's not necessarily written down in a codified standard or in case law or in any kind of book. Sometimes law simply merges or can be deduced from a long-lasting habit. So sometimes customary law is considered to be a source of law. And we see this more often in the context of family law and more traditional types of legislation. So you have this picture here of a traditional wedding in India. The wedding rules as such are not necessarily written down. They are just a habit, a very long-lasting habit, a tradition as such, that is considered to have the same authority as if it would be law. Therefore, we consider this as a source of law. Well, to be customary law, it's generally accepted that you have to comply with two prerequisites. The first is called usus. It's a Latin word in which we basically say, well, it's a habit. It's something we simply do. It's some sort of a tradition, if you like. So getting married in a particular way, using particular traditional rules and so on, can be a habit. And the idea is that this habit is not just a new thing, but is an established practice. It's something we've done for a long time, for a longer period. The second prerequisite would be the opinio iuris sive necessitatis, which is a long Latin phrase that tries to express that all participants should consider this as existing law. If there is a habit, but only one party considers this as existing law and the other party considers this as unjust, then we have a problem. So if one country, for instance, takes a bite of another country claiming that this particular land has been theirs for a very long period in time, so they claim it back, and the other country says, well, actually, I don't agree, it doesn't feel to me as this is just, then we do not comply with the opinio iuris sive necessitatis. However, when all members of a particular society accept that these particular rules in getting married in a wedding are what they should be, then we do comply with the opinio iuris sive necessitatis. In the case of customary law, we should comply with both elements. It should be a long-lasting tradition in a way, and all participants should consider this as existing law. A sixth source of law would be customary law. Customary law are, if you like, general principles of law. In most societies, there are such general principles we have to take into consideration when understanding the law as we know it today. For instance, fair trial is a general principle when we engage in a court case. We have to give a defendant a fair trial. That means that he has resources to a meaningful defense. In contract law, we assume that people engage in a contract in a fair way, fair dealings in contract law. These things are general principles. So the general principles of law could be general principles per country or per region. However, in some cases, we consider a principle so important with such a wide scope that it's almost a universal scope. In these cases, we consider customary law as ius cogens, that is Latin for a universal, generally accepted principle. For instance, the prohibition to torture people, we assume that this is a universal principle and no one should break this rule. So we should refrain from torturing one another in the entire world. Therefore, not torturing each other is considered to be a universal principle, a ius cogens. Well, this was a quick summary of the 6 sources of law. I hope you've learned something from this, and thank you very much for watching this video.